Thanks again to everyone for coming. It's my pleasure and honor to introduce today's keynote speaker, my law school classmate, Professor Dana Remus of the University of North Carolina School of Law. Most recently, she served as senior counsel and special assistant to the president in the Office of White House Counsel, where she led the White House ethics and compliance team and advised White House staff on all aspects of government ethics and compliance. She earned her JD from Yale, clerked for U.S. Supreme Court Associate Justice Samuel Alito. Her research focuses on legal and judicial ethics and the regulation of the legal profession, and she has particular expertise in the intersection of emerging technologies and the practice of law. Her publications include Can Robots Be Lawyers? And The Uncertain Promise of Predictive Coding, where she provides nuanced, detailed accounts of the technological displacement of lawyers and of the ethical implications that arise when lawyers use machine learning technologies. She is eminently versed in the promise and perils that new technologies hold for the law, and I'm so pleased that she can join us today. Thank you very much.
Thank you. I feel the need to clarify that I served in White House counsel's office in the Obama administration. Thank you so much for the introduction. Thank you also, Simon and Leah, who I don't think is here, for putting this together, both for envisioning it and getting us all here. It's a really fantastic day so far, and I'm so grateful to be here. I will say that this is quite an intimidating crowd to deliver a keynote address to, so I will do my best to add something to the discussion, but I can't make any promises given how interesting and insightful the morning has been. I think it's very exciting and a positive development that legal technologies and the impact of technology on the legal profession is getting so much attention these days. But given that various technologies, from the internet to email to Westlaw to Lexis to fax machines, have been impacting the practice of law for years now, it leads one to wonder why there's the bigger hype now, or if there is a bigger hype now. To the extent that there is, I think it's for three principal reasons. Albert introduced us to one of them this morning, forces unrelated to technology that are increasing pressures on lawyers to reduce fees. Historically, both lawyers and law firms were resistant, and fairly successfully so, to adopting new technologies. So long as clients were willing to pay on the basis of the billable hour, there was no imperative to use technology to increase efficiency. But in recent years, even before 2008, but particularly following 2008, client pressures on lawyers to reduce both hourly fees and total hours spent have been intense, and technology offers a potential and promising solution, a tool to reduce costs. Second, at the bottom of the market, the access to justice problem is greater than ever, and again, technologies offer a seemingly promising solution, and one that a number of internet entrepreneurs are enthusiastically embracing and developing. And third, artificial intelligence and machine learning applications appear able to perform a far greater scope of legal tasks than former technologies. Previous technologies principally replaced clerical and supporting staff, but artificial intelligence implications threaten to displace lawyers themselves, something that lawyers are not necessarily happy with. So there is some reason, I think, for greater hype and excitement about legal technologies now than before. But I think the danger of such hype is assuming either that technology is a silver bullet that's going to solve everything, or thinking that its trajectory is predetermined and we just need to follow it and it's going to lead us to somewhere good. So I want to spend my time today raising some questions that I have and things that I think we should be thinking of. Many our speakers this morning have touched on, and I will reiterate them, and some are a bit different. I'll do so by talking about three principal topics. The first two are primarily in dialogue with our first panel this morning, and the third is in dialogue with the second. What legal technologies can and can't do, or my understanding of what they can and can't do. Second, how that's actually impacting the demand for lawyer labor. And then finally, how the profession's regulatory structures are interacting with technology's trajectory. So first, what computers can and can't do in the legal field. With apologies to those in the room that know much more about computer science than I do, I will start with a foundational notion of computer science, which is that computers execute rules. To automate a lawyering task, it therefore needs to be possible to articulate that task in a set of rules or instructions. Computer programs have long been automating tasks that we can describe as a set of step-by-step instructions, or what I would call deductive rules for the computer. Sherry's MyLawBC example of the will template, automated will template, is an example of this type of programming. To boil it down to a simple example, in part, that program is designed to ask the user, do you have children, at one stage in the structured dialogue. If the user says yes, the will include a provision for appointing guardians. At least I'm assuming so. If no, it won't. This is a very clearly articulated set of step-by-step rules. This is the same type of programming that's used for a computer program that searches an online legal database of cases. For example, a case coming out of a particular court citing a particular statute. The computer program looks at each case and says, is this case from the court in question? If no, pass it over. If yes, does it cite the statute in question? If no, pass it over. If yes, list it in the results. So that's the first first type of computer programming that's been around for a while. There are certainly constantly developments or improvements. Where the structure of information processing is not that apparent, where we can't articulate step by step how you get from point A to point B, we may still be able to model a task for a computer using data-driven rules. And I think Ben and Albert's program of BlueJ that we saw this morning is based on this type of programming. So if you are predicting how a court might rule in a particular course of action, and you're a lawyer, you're going to know the facts of the case, the elements of the cause of action. You might do some research about how previous cases have come out, how the court that you are before has ruled in previous cases. You probably can't articulate as step-by-step instructions how you get from all of that information to your prediction. So we can't program a computer based on that first type of programming. However, as they've shown and as other programs have shown, if we give the computer enough data on that type of case and how courts have ruled in that particular case, the computer might be able to develop or spot a pattern based on which it develops an algorithm which allows it to project forward a prediction. Predictive coding software, which has gotten a lot of attention, automated document review, also proceeds on this type of programming. The computer is given a seed set of documents that a lawyer has coded as relevant or not. Based on that seed set, the computer develops an algorithm for relevancy, which once refined can be projected forward. Now, one of the really interesting things about these and other data-driven programs, and surely one of the reasons that they're getting so much attention, is that they show that many lawyering tasks may be more routine than we ever thought. The lawyer doesn't experience her thought processes in predicting how a court is going to rule in a case or determining the relevancy of a particular document as routine, because so much of it is based on tacit knowledge and opaque information processing. But sometimes a computer can make that processing explicit, and in doing so shows that some of these tasks have a much more structured and routine nature than we previously thought. That said, there are certainly a number of limitations to the ability to automate legal work. And so here I want to introduce a note of caution. Most importantly, the task at hand has to have underlying, even if hidden, structure. If the judge makes different decisions in cases with the same case characteristics, if there's no structure to the decision making, there's no computer model that's going to be able to account for all of that data and make reliable predictions going forward. If the judge encounters a new situation that's not accounted for in the data on which the computer is trained, again, the prediction may or may not be reliable. So as a simplistic example, if all the past cases had male plaintiffs, who knows if the computer is going to be accurate predicting the result in a case with a female plaintiff? One would hope it would. One would hope that wouldn't matter, but we don't really know. This is a key point to which I'll return, that computers are very bad at dealing with contingencies that lie outside of the data on which they were trained. One category that remains exceedingly challenging to automate, precisely because it is so unstructured, is human interaction. Natural language processing has certainly come a long way in recent years, but it has a long way to go, and it's still based on linguistic features and not meaning. Meanwhile, effective computing, or dealing with emotions, has made impressive advances in things like measuring physiological responses or looking at facial responses, but this leads to conclusions like user is frustrated or user is happy, which again is really impressive, but it doesn't come close to navigating the diverse array and infinite number of emotional states that we certainly can't articulate ourselves, and yet we navigate all the time. And I raise this because I think that in unstructured human interaction is a key part of lawyering, that maybe it will not be a key part forever, but it certainly is at the time being. So with that as background, I'll turn now to how advances in both types of computer models, those based on deductive instructions and those based on data-driven rules, are impacting the market for lawyer labor. In some areas, the displacement of lawyers has been or soon will be significant, supporting some of the headlines. But in others, I think it's highly unlikely that lawyers will be replaced anytime soon, precisely because the underlying work is insufficiently structured to be automated at this time. Interestingly, I think that the fault lines aren't necessarily obvious or intuitive. Tasks that on the surface look fairly similar to us actually pose drastically different challenges in the task of automation. So consider document drafting as opposed to legal writing. I define document drafting as producing standard legal forms like contracts or wills or trusts that express as clearly and unambiguously as possible the intent or agreement of the parties. The task has been successfully automated for some time precisely because it is structured. Specific terms and provisions certainly differ, but the overall organization and content of these documents are relatively consistent across instances. This is why lawyers have long been using standard templates or forms in starting the process of drafting. Yes, they need to be changed or altered, but it is effective to start with a basic form. Legal writing, which I define as the production of written product that either characterizes the state of the law or its application to particular factual circumstances, presents a very different situation. Certain aspects of, say, a legal brief are certainly consistent across individual instances, like the introductory or concluding material or the statement and explanation of the standard of review. But much of the meat of the legal brief entails and requires conceptual creativity and flexibility that is beyond the current scope of computers. So the legal analysis section entails a complex interplay of law and fact where the facts in question dictate the relevant law, but then the law tells us which facts are particularly relevant. The use of precedent, which becomes second nature for a lawyer, is exceedingly difficult to automate because the same case can be used to support opposing positions. Making an argument for one as opposed to the other requires differentiating between the binding holding and the persuasive dicta. It also requires placing that one case in a line of precedent. These are things that are very, very difficult to automate. I think that people tend to be a bit too optimistic about the trajectory of automation of legal writing based on automated press stories that automate sports writing, or even Ross's production of simple legal memos. But I think the comparison to sports writing is inapt because describing what happened in a baseball game is at base a fairly structured task. The game can be reconstructed based on the play-by-play game feed. As for Ross, it's impressive what they are doing, but at this point, the legal memos are simple explanations of the state of a law in a particular circumstance. At this point, it still requires a lawyer to review what the program has spit out. The lawyer revises, adds, and then puts it out. So it's an example of computers, no questions, helping lawyers, making lawyers more efficient, but it is not automating the legal writing process at this point. Another useful comparison, I think, is between document review in discovery practice, which has been successfully automated, and document review in due diligence, which has not. In discovery practice, the goal is to identify documents that are relevant to a preset list of topics and questions. Having the topics and questions in advance makes it a structured task. We can program the computer to look for documents with a single set of linguistic features, all responsive to those questions and topics. In due diligence, the very goal is to look for surprising or unexpected things, which at base is an unstructured task. It is exceedingly difficult to program a computer to look for things you are not expecting. So a lawyer, and I am here idealizing a lawyer, I realize there are problems with comparisons between automated document review and human lawyers, because human lawyers tend to get bored and not pay nearly as much attention always as they perhaps should in document review. But our ideal lawyer would hopefully notice a particular contractual reference that's in violation of, say, the Foreign Corrupt Practices Act as highly problematic and note it. unless there is something in the training data to tell the lawyer to look for that, the computer will miss it. So there's significant variation in the extent of the inroads that computers are making on lawyer labor in different areas, based primarily on the underlying work and whether they are structured or not. One of the really interesting and to me surprising things that my co-author and I learned in a recent study we did is that, contrary to conventional wisdom, where computers are making inroads is not directly correlated to who within a law firm typically performs that work. The standard story was that computers are eating lawyers' jobs from the bottom up. So if we remember Albert's pyramid this morning of the typical law firm, they were starting at the base and going up. And what we discovered is that the pattern is not nearly that neat. Certainly some, there are some points that support that, like document review. In discovery practice, in large cases, it is widely used, it is very effective, and that is primarily performed by junior associates or now contract attorneys. But other tasks don't neatly map that. Legal writing, which, as I mentioned, is still very difficult to automate, which is still primarily performed by human lawyers, is typically performed in the first instance by junior associates, who are either writing memos to inform their partners of the state of the law in a particular field, or writing the first drafts of briefs that their partners will then edit. And I think probably most problematic to the direct correlation between what's being automated and who within a firm performs it is the difficulty that I already noted of automating unstructured human interaction. At least at the present time, that permeates lawyering at every level. Giving a client sophisticated advice is typically performed by partners. Investigating a client, doing basic intake may more often be done by a young associate, but both require human interaction, and both at this point are resistant to automation. Now, there's an important category of computer advance that was referenced this morning that I haven't yet discussed, and that is programs that don't just set out to aid lawyers or make lawyers more efficient, but that re-envision the underlying tasks to obviate the need for lawyers. Expert systems are, I think, the ideal example of this. Expert systems, as we saw, take a particular, generally fairly narrow legal task and structure it or present it as a structured dialogue with the user. Once the system is designed, it can be scaled to many users at a cost that is far less than if that legal advice was delivered to each individual one by one. Do not pay that we saw is an example of this. BlueJay's home office classifier I thought was going to be an example of it until I realized that a lawyer is using it, but to the extent that it might someday be directly marketed to clients, it would be an example. Another example of this general category of re-envisioning the task itself is online dispute resolution systems, which negotiate resolutions to disputes, generally in the e-commerce world, between two users without the involvement of a lawyer. I think that in the future, this category will be significant, and if we're intentional, it can be very significant in addressing some access to justice needs, but I don't think it's having a significant impact on the demand for lawyer labor right now, primarily because it's addressing situations where the individuals would not otherwise be going to a lawyer. Those people with parking tickets would not otherwise hire a lawyer to overturn their parking ticket. Most of the e-commerce disputes for which online dispute resolution is used are low stakes and would not justify an individual hiring a lawyer. And so I come to my less than exciting conclusion that computers are impacting the demand for lawyer labor and making impressive inroads on legal work, but that they're not doing so nearly to the extent of some of the headlines we've seen in recent years, which predict the end of the legal profession and claim that robots will have taken all lawyers' jobs within the decade. Of course, the pace and trajectory of technologies and of their impact on the demand for lawyer labor won't develop in a vacuum. The market for legal services is highly regulated, and the profession's regulatory structures have, and unless there's drastic changes, will continue to have a significant impact on that trajectory. Critics of the profession contend that its regulatory structures and ethical rules are all bad, self-serving tools of protectionism. I think, and I want to start out by acknowledging that there is no question we can all find examples and situations in which that is true. I also want to say that I completely agree with the critics who contend that the profession's principal mode of regulating new technologies at this point, the unauthorized practice of law rules, it's ineffective. However, I don't follow or I don't agree that we should jump from the conclusion that existing approaches are ineffective and maybe even harmful to all approaches are ineffective and harmful. To the contrary, I think that key rationales or functions of professional regulation, namely protecting consumers, ensuring access to legal services and quality legal services by all segments of the population, and protecting the basic integrity of the legal system are implicated by new technologies, suggesting that we should regulate better, not that we should not regulate at all. So, starting with consumer protection. It is certainly the case that in some situations, computers and automated legal services beneficially eliminate human error and may actually increase consumer protection. But as Frank argued, I think persuasively before, that's not always the case. And in fact, it's very dangerous to assume that that's even often the case. I've already alluded to the problems that stem from computers' inability to deal well with unanticipated contingencies, and I think that that's a really useful lens through which to think about this question of when do computers do as good a job, maybe even better, a better job than human lawyers, and when are the risks actually quite high of a mistake. LegalZoom, which is convenient and effective in so many situations, has had trouble dealing with individuals who have exceedingly complex tax situations. Now, that would not be a problem if the computer's response to those individuals consisted of, you have a complicated situation, you should see a lawyer. Instead, in both instances that I'm aware of, the program went ahead, produced the will or the contract without regard to those tax situations, and then it only came to light far later when the individual had incurred liability. Returning to predictive coding, which I like using as an example because I think it's really one of the success stories of automation, and even there are cautionary notes. Many predictive coding tools are ineffective at spotting hot documents in a case. You know, the silver bullet that wins or loses a case. And the reason I think is fairly interesting, turns out that we as human beings often change our tone of voice or the language we use and become excessively vague or formalistic, or just resort to full-on code when we're acquiring legal liability or making a decision we're nervous about or think might be wrong, which means that the language used in an email or a document that's very relevant to intent and decision-making in a case might not be spotted by the computer because it wasn't prepared for it in the training data. So if there's an email on a key date in a case that just says, all set, it's done, you'd hope the lawyer would say, that might be relevant. Unless there's something about those words in the training data, the computer would not spot it. Now, I should say that that was accurate as of 18 months ago. Many predictive coding programs have now addressed this problem by expanding kind of the baseline of information on which they're trained beyond documents in a case. So it's a good example that, like technology in all fields, we can, it will inevitably improve and we can guide that improvement, but we very much have to be cognizant of the risks it's creating and very intentional about addressing them. Now, I want to back up and say, let's go back to assuming we haven't addressed any of the problems, and we will just take as fact that certain technologies do not perform as well as a human lawyer. My argument is not that the trade-off of lowered quality for lower prices is never worth it. I think in some situations, it likely is worth it. I think for many individuals who just need a simple will, a computer program that provides that simple will is all that they need. They do not need the additional lawyering that would come from a lawyer. They don't need the lawyer to spot greater complexity and make novel, creative arguments. So just because we wouldn't say that automated will program is equal to a lawyer, that doesn't necessarily mean that automated will program isn't a very good thing. However, the trade-off is going to be very different in different situations. If we're talking about a child custody dispute or asylum, I think the trade-off is very, very different. There, we want the lawyer. So the questions that then arise that I think are absolutely critical to be addressing, but that are very hard, entail who makes those decisions as to when the trade-off is appropriate and where it's appropriate, and what factors should they be considering in making the decisions. I think that particularly in the individual services space, well, I shouldn't say that, the corporate space too. I think overall, there's a lot of enthusiasm for the notion that clients should be making these decisions for themselves. And there's a lot of persuasiveness to that argument. There's a lot to be said for client autonomy. But I want to introduce some notes of caution here and note a few reasons that I think we should think hard before just saying this is a decision for clients to make with respect to themselves. The first and most straightforward reason, the fundamental justification for organizing law as a profession is the complex and esoteric nature of legal expertise. Now, there's no question that this justification is overplayed sometimes and used to protectionist ends. So it's hard to resort to it. But it's also no question the case that individuals who have not been trained in the law are not in a particularly good situation to determine when a legal program can protect their legal rights and when it can't. Second, as we've just been talking about, is the access to justice issue. It's a key obligation of the legal profession, and I don't think that we can, and I think our whole discussion just supported this notion, we can't solve the access to justice problem by redefining it as access to computerized services, whether they're effective or not. That does not mean that technology should not and cannot be a part of the solution to the access to justice gap. And I loved seeing Sherry's examples, and it was really helpful to me to have a visual of some of them, to think through, okay, how can technology be used to increase access without just seeing it as a cure-all? I think using it, and lots of legal services organizations in the States do this, and I think here too, using it to make the intake process more efficient is very smart. I also think that there are creative solutions by some courts which are offering hybrid legal services to pro se clients, combining computerized intake with human assistance. I think that is interesting and encouraging. And then there was a reference to what law schools can do, and there are a number of law schools, as I hope Dan will talk about this afternoon, he's at the forefront of a lot of this, who are developing various programs that get students involved in either actually programming apps or using apps in ways that make legal services more accessible, while also addressing the fact that there's a point at which the person needs to see a lawyer. And how do we ensure that the technology builds that in? Okay, a final set of issues that I'll mention are of a different sort, and they come back to your guys' discussion this morning that was fascinating, and they're specific to the data-driven programs. We started to talk about this morning, and I'll just expand on it a little bit because I think it's really interesting and important to think about. Like big data generally, my understanding is that these programs give a user an outcome without a detailed explanation of, say it again? Of the combination of factors that produce that outcome? Okay, so.
Families of methods, and they work in different ways. They're black box methods and ones that aren't black box methods.
Okay, so that's, I guess, then this, yes, fits into my kind of argument in this space, which is we can use these programs to great ends. Like you suggested, the idea of having a race-neutral predictive algorithm for sentencing suggestions that can then be used to compare to actual sentences in cases, which then can be used to highlight human bias. But I do, at the same time, worry that if we're not intentional about using them in that way, there's a danger that I just want to flesh out a little bit, which is that discriminatory patterns that we don't recognize right now get embedded in a way we don't recognize. So what I'm thinking of is an algorithm that discovers a weak correlation between the race and ethnicity of litigants in a particular court and the court's outcome. If the algorithm notices that, it's going to factor that into its predictions. But if it's a very weak correlation, it could factor them in a way that doesn't immediately highlight the results to us in a way that allows for accountability, and yet it's baked in there, and then those predictions impact how litigants or potential litigants act in the shadow of those predictions. So that's my danger. I was going to come around to this notion that we can use the technology in a positive way to counter that danger, and even to to go above and beyond countering the danger of bias in the technology and counter bias that occurs right now in human decisions, but that it's got to be an intentional thing, and that it's going to be an expensive thing. And I'll stop here, that this just folds into, in my mind, another argument of why we do need the profession to be engaged, and we do need regulation in the sphere, because I think without it, the market will just push these technologies in a way that pushes the reasons aside and just pushes towards outcomes. So I will stop there. I'm very anxious for your thoughts and questions.
small, but first, thank you very much. I think this was very illuminating, and as you may have guessed, I totally agree that it's very important that the lawyers themselves get their fingers behind what's happening inside these systems. Small methodological point. At some point you said that if there is no structure in the data that is being researched, then the system cannot find the structure. There is a wonderful example by one of Google's AI systems. I think it's called Dream Technique, but it's something with Dream. That I think clarifies that that is not a fact. So maybe it's not what you meant, but I still think it's very important to make the point. So they showed a program, animal faces, nothing else. They trained algorithms unsupervised. That means you give the algorithms the data, and actually you tell the algorithms, go look for patterns. That means you develop a hypothesis space with mathematical functions that you feed, and then the algorithms is going to find patterns because that's what its job. It will always find patterns. After you've trained these algorithms on the animal faces, they showed plants. And we are not surprised. The algorithms, the machines, saw animal faces. And actually there is a very nice online, you can easily find it. Now, is this surprising? No, of course not. If you train something on animal faces, it will see animal faces everywhere. What this should remind us is that things are much more complex and not so obvious, that patterns are going to be found. And this is based on mathematics, not on reasoning. And this will have enormous implications for all sorts of outputs that are going to be given, and you can always translate them and say, well, it's these factors that gave this outcome, but they might be absolute nonsense. And it's very important that we have people versed in software verification that can begin this conversation, and that lawyers begin the same conversation.
Thanks. It's super helpful and interesting and leads me to a few different thoughts. First, I misspoke if I said a computer can't can't help if there's no structure in the data. I meant no structure in the task. You know, if the task is performed in completely unpredictable ways. So I stand corrected there, I misspoke. I do think it's fascinating, and this is a good revision on kind of how I was presenting this, that if we give a computer data, it likely will find a pattern. The problem is it might not be the pattern we want it to find if we're not intentional. You know, it might find an animal pattern in a completely different situation instead of, and predict a result that is not at all what we intended. So that brings me to the next point, which you kind of brought home that I just think is incredibly important to focus on, which is that, you know, we talk about artificial intelligence and machine learning as if computers have a life of their own. And we may get there, but at this point, we have to train the computers to do what we want them to do, such that they are limited by their training. I think it's a useful cautionary note to comparisons between Jeopardy and legal services. I get this question a lot. If a computer won Jeopardy, why isn't Ross going to give answers to every legal question that's out there in no time at all? Isn't it the same thing? It's answering questions. It's much harder to train a computer to give an answer to a legal situation, a legal question that applies law to facts, than it is to return a factual answer to a question of the type that Jeopardy usually gives, because computers cannot summarize passages. They can't summarize different paragraphs or different cases. They can return relevant chunks of text that are very responsive, but they can't bring it together in an answer. So question and answering systems that are based on IBM Watson require a human lawyer to link up inquiries with responsive text passages. Once that's done, it's really cool and really effective, but it takes a lot of front-end lawyer labor. And it means that economically, it's going to be hard to get IBM Watson to a place where it can effectively respond in a whole number of areas of law. The last point, I cannot kind of echo enough that we need lawyers who, I shouldn't even say we need lawyers, that's me bias starting. We need people who have both legal expertise and computer science expertise. And we need groups of people that bring that expertise together. One of the things that was so exciting and fruitful and helpful to me about my last project was teaming up with someone who has deep background in computer science. That's not as good as if one of us had both, but I think bringing the two fields together, and it's happening more and more, and it's really exciting, has to be kind of the first step in the path ahead.
Thank you. Just want to go back to your point about predictive coding, and I'm wondering what you think we can do about mitigating dangers of machine learning with so many closed data sets. And what I'm thinking of is Mark Zuckerberg has written about how he knows he's going to have a better AI product than Google because Facebook Messenger is a much more natural set of human speech than search queries are. And so if these data sets remain closed, how can we mitigate some of the concerns you've raised?
Okay, I think it's a fascinating question. I'm embarrassed to admit, but I'll be very candid, I don't understand exactly what you're asking, so can you flesh it out for me a little bit?
Sure, certainly. So if these data sets that we require to, like the corpus of knowledge to feed these legal tools are owned by companies and are not shared, how can we mitigate these concerns without open data?
Oh, yeah. If I knew the answer, I'd be really famous and or really rich. I don't know the answer, but I will say that I think it's a very important question to be asking, and it ties into the whole question of will legal technologies actually make legal services less expensive, and if so, exactly how that's going to happen. I think the story is much more complicated than the message often is. The message is often this is going to bring down costs, and it's because the comparison, and the studies in predictive coding follow this. It's, okay, here's a set of documents to review. If you do it with a computer, how many hours does it take? If you do it with a human, how many hours does it take? It certainly brings down the costs of human labor devoted to those documents, but there's a whole number of reasons to think there might be increased costs elsewhere. Some companies are patenting their legal technologies, offering them free for an initial period, and then licensing fees kick in. And this was raised this morning. There can be this battle of the experts or escalating fees if both sides have the technologies, and it's just creating higher and higher costs. That's another one in predictive coding I've thought some about, that you have to have individual lawyers who are making the decisions of which protocols to use, which are appropriate for which data sets, and often going into court to defend that. Then you're going to have experts that you're paying for. So that's a long-winded kind of expansion of your point that there are costs here, other than a lot of professional attention to it and public attention to put pressure on data sets being closed. I don't know the answer, but thank you for the question.
Just to go back to your example of LegalZoom in certain situations giving poor advice. I guess for me it seemed like the relevant comparison isn't LegalZoom versus some person who's always going to give perfect advice. It's a comparison to what sort of advice that, like people are generally going to get on tax issues or whatever. Because a lot of lawyers are going to give poor advice in some situations as well. So I'm not super well versed on the way that most legal regulatory associations respond to lawyers who give poor advice, but
They
I suspect
don't.
it's, oh, okay.
I mean, they aspire to. They are chronically underfunded and under-resourced. So for purposes of your question, I think it's fair to say we shouldn't be relying on them.
Okay. So my question was going to be, why doesn't it make sense to apply a sort of similar approach to technologies that offer legal services or legal advice? So if they give bad advice, then they're sanctioned or no longer allowed to do that. Well, why do you need like an overarching theory for what sorts of tasks or areas of the law that technology wouldn't be able to assist with? Why can't it be a sort of responsive, case-specific sort of thing?
Okay, that is an excellent question. Let me start by saying that this talk is very much a product of my mindset, which is in the paper I just finished, which was thinking through, okay, where is automation doing a good job and where is it not? I think the underlying theme of your question, which I take to be, why are we saying A or B? Why aren't we thinking about, okay, how to use these technologies effectively, whether they can replace the lawyer or not? I am 100% with you. I think that's how we should be thinking. You also raise a really important question that I get myself in trouble for a lot and have to constantly remind myself, what is the baseline? I fall into a comparison of computerized services versus what I want lawyers to be. And that is, creates the danger of the perfect interferes with the good or the better. So I think you're absolutely right to note that we shouldn't assume that lawyers are perfect. Now, my counter argument to that is we also shouldn't assume that not so great lawyer or technology are the only options. We shouldn't think that we can't improve the status quo in other ways, which I think just factors back into your notion of let's just think creatively about how to use these going forward. So as for the consumer protection response, I've been thinking more and more that we need regulatory bodies for various legal technologies that involve techies and involve lawyers. So I don't think it has to be purely professional regulation. I think there needs to be some regulation. Right now, and this goes back to the liability issue, there's just not very much regulation at all of a bunch of the online service providers that are not ostensibly providing legal services. One last thing that is not entirely necessary or responsive, but I can't help but noting, the interesting things about the two LegalZoom categories are they were individuals with sufficiently complex tax situations that I think a lawyer, well, actually, I won't comment on that, but they were unusual. They weren't your standard LegalZoom user.
Following on the previous question, because regulation is one aspect, there is another aspect that is insurance. I mean, lawyers have malpractice insurance, and what we see in other areas when automation has happened, say, for example, Tesla offering now insurance for their self-driving cars as part of what they do. I mean, the insurance market for, say, any type of a program is probably easily can be obtained over time. I mean, once there are data that are measurable, they're insurable, generally speaking. Would it then put a level playing field if effectively somebody is not providing a good quality decisions in automated fashion? The insurance will be very expensive, and somebody provide a good, it will be cheap, and the same with the human. So it will put like a economical level playing field if there are similar insurance requirements across this, and it's just pricing that will depend from the quality.
So yes, that could be an answer. I think politically it's going to be very difficult. I mean, it would only work if these service providers, if it was required that they have insurance, right? I think politically that's, I can't envision us getting there anytime soon. If that happened, it would certainly respond to some categories of harm, obviously financial harm. Without having thought about it too much, I don't think it's a complete answer because there are lots of legal harms that can't be purely compensated in financial terms. You know, one broader category of worries that I have that's not sparked just by this question, but by, you know, whenever we get into the realm of two-tiered services and, you know, address the top of the market and the bottom of the market differently, and, you know, within each realm, just make sure individuals are being protected and getting services. It raises the question of how the two spheres interact. And most problematically raised by your question, how there's then, how the law evolves over time. That, you know, how, and I'm getting, as I speak, I realize I'm getting a little far afield of your question, but while I'm on this theme, I'm going to roll with it. You know, if at the bottom of the market, we just have computerized legal services, even if the computerized legal services have effective responses to harm in individual situations, and at the top of the market, you've got fancy lawyers with legal services, able to make arguments for legal change over time, there's really going to be an overrepresentation of corporate interests and an underrepresentation of poorer interests in law reform over time. So I'm always a little resistant to any solution that's just address the problems in one sphere without thinking about what's happening in the other sphere.
Hi. I really like the talk. And I was sort of thinking about the typical language of automation and job loss. It often centers around performance to price ratios. And price is a rather agreed upon concept. We kind of know how much things cost. It's the performance side that actually is rather contested and is a bit of a moving target. And we have to ask ourselves, well, what do we mean by legal performance? What is good legal performance, or what is average legal performance, or whatever? What is satisfactory legal performance? And what I think is interesting is it's easy to think of that as fixed, but it also changes, and I think you make reference to this when you talk about the structured nature of the law. So we could imagine that the gap between, say, typical lawyer performance and machine performance would be narrowed if we simply made the law full of rules as opposed to standards, right? And we have some choice there. That's a legislative choice. And if it's a legislative choice, it's also a political choice. And it doesn't even have to be on the legislative end. Even if we think about adjudication, there's politicized choice with regard to the structural law there too. So for example, if we want to be naive textualists and we just declare that the way to perform legally is to do a naive textualist approach, the technology already exists to do that rather reliably, right? But if we wanted to be living constitutionalists, I mean, we might be talking about waiting until pragmatics gets involved into natural language processing, which might be like 2100. So you could see how people, interestingly, on the rules side of the spectrum, who tend to be somewhat conservative, people on the left who tend to be more into the pragmatics of law, that this could become a political debate that could shift basically the goalpost and shift what we decide adequate legal performance is. Do you have any thoughts on that?
I think that's fascinating. I feel like there's lots that could and should be written on that. The two buckets of thoughts that come to mind. First, it reminds me of folks who fairly are saying, you lawyers have been saying, your services are so special and bespoke and individualized in different circumstances. And there really needs to be benchmarks to measure legal standards and legal success. And once you have those, we can figure out where the computer performs, figure out if the cost differential is worth it. And so I think everything you're saying is a really effective, there's something to what they're saying. No questions asked. There's something to it. But I think you introduce both important complexity and an important pushback as soon as we kind of say, okay, let's standardize everything. We are fundamentally changing the nature of the legal system. The other thing that it makes me think of is even when we're ostensibly looking at performance measures, like does the computer perform to the level of a lawyer, we are looking at the outcome, the end result, and not thinking through the fact that the computer gets there a very different way than the lawyer gets there. And that very different way doesn't, in the way I'm talking, affect this specific outcome, but if we do that more and more, it certainly affects how the legal system is functioning. And this kind of ties into this whole bucket of questions that we've been talking about with legal prediction. So it seems like you are kind of coming at that from the other side, saying if our goal is to automate, what does that mean that we have to do to the legal system? And I like it because it's a different angle and window onto how computers perform differently. And it lets us look at the end results, even though we're looking at them as a way to get to the automation. So I think it's super interesting.
Oh, thanks. I mean, just a wonderful talk. And I want to make 2 points. One is that I do think, just to build on your last point, that in many situations, legal reasoning by persons for persons is constitutive of the legal situation. It is not merely one way of addressing the legal situation. And that may seem circular, tautological, et cetera, but I would also say that if you have any reservations about killer robots deciding whom to execute, you might want to apply some of those reservations, I think, in these other scenarios. The second point I guess I would make to get more to the pragmatic next steps is, I know that North Carolina had mooted a rule, I don't know if it got passed, that restricted the ability of software providers to impose these one-sided terms of service that would disclaim all liability for bad legal advice. Are there other examples of where state bars, other regulators should go? I really liked your idea of like an FDA for legal technology. I think that's great. Any other practical steps we could take?
So I kind of can't agree more on the whole notion of lawyers and lawyers' interactions with clients being kind of constitutive of the state, which puts lawyers in a different category than other service providers. And I think that's important to keep in mind. So yes. On practical steps, I'm not always so good on the practical, but I would go back to, I don't have specific answers. I am, and this is kind of, I know, kind of a dangerous, what every academic says, but I do think that whether it's through the state bar or the state court system or the state government thinking the lawyers are taking too long, I think it's critical for states to have commissions that join, however they do it, join legal expertise and computer expertise, and think both about how that can be addressing access to the courts, access to justice generally, and think through the dangers that can come from that, and think through regulation. So basically, I just think that as a process point, we need groups that are really focused on this.
Great, so I think that's a great place to finish. Thank you again
Thank
so
you.
much.